Let me ask lead counsel to place them.
Good morning, Chairperson. Good morning, Commissioner Baloyi, Commissioner Kumalo. My name is Ndwamato Eric Ngwedo. Ngwedo, N-W-E-D-O. So you need to roll your tongue a little bit, Chairperson. That's vendor. So I'm counsel for Dr. Lebeya, who appears before the commission this morning. I'm not alone, Chairperson. I'm with my instructing attorney on my left. I will also just give you an opportunity to introduce yourself. Yeah. Okay, it's Ms. Zintle Dube from Lucky Tekiso Attorneys. They are the instructing attorneys in this particular matter. I thank you, Chairperson.
Good morning, Chair.
Oh, good. Good morning, Ms. Sigels.
Good morning, Chair.
Thank you. You were referred to just now as General, so Doctor. So I don't know whether to call you Doctor or General. What's your preference?
Good morning, Chairperson. Good morning, Commissioners. I prefer Doctor because it's a recent one.
Oh, good morning, Doctor.
Chair, I would have said advocate because as far as I'm aware, Dr. General Lebeya is an advocate.
Yes, I do know that.
I am an advocate.
Yes.
I am a Lieutenant General, retired. But the Doctor one is the latest in terms of the seniority.
Hence the preference. Thank you very much, Doctor. Thank you. Ms. Sigels Ngube.
Thank you, Chair. Chair, the General will be sworn in.
Doctor, will you be swearing or affirming?
Swearing.
Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
I swear that the evidence I shall give shall be the truth, the whole truth, and nothing else but the truth, so help me God.
Thank you very much. Mr. Ngwedo, very early, no, in fact, very late last night, I sent a text to Ms. Sigels Ngube and I asked her to engage you on how best to deal with the doctor's statements. I think they are the longest we've ever had, totaling 170 pages. We would take forever if we were to go through all 170 pages. Ms. Sigels Ngube, I hope you were able to reach agreement on a practical way in which the statements should be dealt with.
We have, Chair. I did discuss it at length with my learned friend and with, now I have to remember to say doctor instead of general, with the doctor, and we have come up with what we think is a practical approach. What is unavoidable, I think, is that we'll probably spend the whole day on just leading the doctor's evidence on both statements, and we will have to arrange a further date for the cross-examination. But we have come to an arrangement that will significantly reduce the need to read from the statement, and we think at this point we're probably about I would say we've reduced it by about 60% on the first statement. The second one, we'll try and come to an arrangement during tea.
Yes, all right. Thank you very much to both of you for that. Thank you. Yes, Ms. Sigels Ngube.
Yes, Chair. If I could then just orientate everyone on what is before the commissioners and then how we propose to deal with the with the first statement. So, Chair, there are, the first file is file 1 that has the doctor's main statement, which is 1 to
Sorry,
page
I don't mean to
124.
interrupt, Chairperson. I thought my learned colleague would remember what we have discussed. There are
Yes.
certain aspects that we need to place on record.
Oh, yeah.
Prior to proceeding. I'm happy to do that maybe after maybe she may have
Yes,
done.
Chair.
But I just wanted to highlight that there are certain aspects that we want to place on record from Dr. Lebeya's side.
Okay.
Chair, we will get to that once I've dealt with the housekeeping, just so that we know what files we're dealing with. We've got and it's before the doctor deals with his evidence. File 1 is his statement, the main statement, page 1 to 124, which is dated 25 November 2025. Then there are 2 files of annexures that go with that statement. It's file 2 and 3. And then there's file 4, which is the supplementary statement, and that is dated 4 August 2026, and that also has 2 files with annexures, so that would be files 5 and 6. Then, Chair, we've created a core bundle, which are just extractions from exhibits of other streams where Dr. Lebeya's name has featured, which we thought would be relevant for purposes of his evidence. We won't get to that today because it deals with cross-examination matters, but just to place that on record. And then there was a annexure, which is National Instruction 2 of 2001, which General Lebeya had referenced regarding informers and how informers are to be dealt with within SAPS, which we've also included in that bundle. And Chair, we can now deal with the issues before we go to the doctor's statement. It relates to a matter which my learned friend accepts the commissioners have no say in, but it is an issue which I understand the doctor to be very passionate about regarding legal representation for purposes of his appearance at the commission. Chair.
Thank you. Yes, Mr. Ngwedo.
Thank you, Chairperson. I'm indebted to my learned colleague for remembering that one. Chairperson, Commissioners, the issue that Dr. Lebeya is quite keen to place on record, and I need to be very clear, Chairperson, that this is not a preliminary issue. It is just an issue that he wants to place on record regarding his legal representation. Firstly, Dr. Lebeya is here before this commission at his own costs, including, the costs of his legal representation. On 12 November 2025, Dr. Lebeya made a formal application within the SAPS for legal representation. However, that was denied or declined. And this happened through a formal notification dated 6th January 2026. What is evident with the communication that has come through Chairperson and Commissioners is basically that the decision maker in that particular application happens to be one General Musikidi, who, and again, I need to be very careful about it, Chairperson, these are issues that he's going to traverse during his evidence. So it's not something that is being submitted from the bar. So they are in his documents, they are in his main statement. And therefore, this a person had actually used to work under him when he was still the head of the DPCI, or the Hawks as we know it. And is one person that he had tasked to investigate the issues relating to one of the streams that my learned colleague is going to traverse, the Port Shepstone matter. And there was a report that came out of that, and there were certain recommendations, and Dr. Lebeya had clearly annotated in that particular report that he needed to discuss a certain paragraph 6 that arise from that particular report. That never happened. It turns out when he made this application, the very same person is the one that becomes the decision maker, who then declines General Lebeya's or Dr. Lebeya's legal representation. Chairperson, what we submit, as I indicated, we are not casting this as a preliminary issues, but we submit that General Msigidi ought to have recused herself from adjudicating that particular matter because of the conflict that is apparent in that particular matter, and also the mere fact that the issue relating to the Port Shepstone drug bust is central as well in this particular commission. That didn't happen as we know it now, and it's on the record, and we submit that the reasons that have been provided by the subs for declining that particular application are really frivolous, to say the least, because one of the issues, and I will paraphrase Chairperson because I don't want really to belabor this point that much. One of the issues they raise in the letter is that they, amongst others, they do not, they are not actually inclined to provide legal representation because his version differs with the version of other subs witnesses. That is problematic, Chairperson, because I mean, if one actually reads that, are they implying that there should have been alignment of versions from Dr. Lebeya with the other subs witnesses that are appearing before this commission? That is problematic. Dr. Lebeya is here before the commission, and he has willingly, and he has cooperated with the commission since October last year, up until today, with all the postponements that has occasioned, which we don't blame it on the commission. He has remained patient to come here and assist this commission in reaching its objectives, but above all else as well, to clear his name in the manner in which he has been, aspersions has been casted on him. So, Chairperson, what we really submit in this regard is that this needs to be taken in light of what has happened, lately. And we have been instructed that on or about February this year, Dr. Lebeya was subpoenaed to appear before the Hampepe Commission, the one that is dealing with the TRC cases. He made similar application based on the same National Instruction 1 of 2017, which is the guiding document within the South African Police Services. He made similar application. That application was granted. And that was after the one that he submitted for this commission had been declined.
May I find this out? Do you propose asking of us to do anything, or I just want to get an idea why we should be apprised of all this? I'm not being unsympathetic at all, but I just want to get an idea.
Chairperson, what we ask of the commission, Dr. Lebeya is here to assist the commission. And we, at the very least, if the commission finds it appropriate, we submit at least this matter needs to be flagged with the SARPs for a possible reconsideration. Because
wasn't the proper course for Dr. Lebeya to follow, to review the SARP's decision not to fund him? Is that not what he should have done in January already?
Chairperson, that may very well be so. We do not deny that. It may very well still be a course of action that he may consider. However, we hold instructions to place these things on record because that actually has potential of inhibiting him in assisting the commission the best way he can.
You said the verb you used was that this is for the commission to flag. What does flagging entail exactly? What's its practical effect?
Chairperson, what we submit is that the flagging may very well be Dr. Lebeya is here. He has always, as far back as February when he was first subpoenaed, he has always been keen to come and assist. This is a commission of inquiry that is actually aimed at getting to the bottom of the issues of criminality and the interference in the criminal justice system. And therefore, we submit, Chairperson, that it is prudent, even though the commission may just note and not...
Can you please just zoom in on what you mean by flagging in practical terms? What does that entail?
Chairperson, if that may just mean a letter or so, regarding the issues that have been raised, that would be fine by Dr. Lebeya. We understand, and that is why I put a big caveat when I started to say it's not a preliminary issue. We understand that it's not your decision. But if the commission finds it that there is nothing, even in by way of just a mere letter, then we will rest it at that. The general is here. He wants to assist the commission.
I'm not sure. We normally use, we as lawyers normally use standing in the context of litigation, but I will use it loosely here. I will say I'm not sure at all that the commission would have standing to come and to assist the general in this regard and to write to send a letter, as you suggest, to SAPS about this matter. I'm not sure what standing we would have in that regard. I'm thinking off the cuff here, of course, and again, I repeat, I'm not being unsympathetic to the doctor's plight. I don't have to give legal advice, and in fact, I ought not to do so. But I think the best course, I repeat, for the doctor is to review the decision of SAPS, and it doesn't matter that, of course, there are, if it's a budget process, there are time limits. Of course, if you're out of time, you can apply for an extension of that period. All of those things. Of course, if it will be a budget-based review, I don't know what review you might have in mind, and the fact that by the time that review is finalized, General Lebeya will have testified and finalized. It doesn't matter, because if he succeeds and it's held finally that he ought to have been funded, he can be funded at that late stage, and that will still be to his advantage. I should not be doing this, but I guess I just want us to move on and to make the point that I do not think we can come to the doctor's assistance. Just a minute. Yeah, there may also be, as Commissioner Kumalo whispers to me, some internal processes that may first have to be exhausted before litigation.
We accept that, Chairperson. As I indicated when I started, we wanted we wanted to place these things on record.
No, I hear you.
It is an issue that Dr. Lebeya felt very strong that it needs to be canvassed. We understand the limitations on your end, and we'll leave it at that.
Thank you very much.
Perhaps while I'm still on my feet, if I may just conclude by just highlighting just one aspect that will come, and we've discussed it with my learned colleague before we came in here. There is a certain portion in the main statement where clearly Dr. Lebeya has indicated that the annexures related to those particular paragraphs is Annexure 9, 19, 35, and 44 that are top secret and classified documents. Dr. Lebeya basically will seek guidance from the chairperson on how to deal with those top secret classified documents when we get to them. He has them in his possession, and will take guidance from the chairperson and the commissioners on how best those issues can be dealt with.
I prefer that we should hear from the two of you how they should be handled, and we'll then decide based on that. So please engage each other on that, and
we'll do that during
and come with a proposal. Thank you. Let's start, please.
Thank you,
Thank you,
Chairperson.
Chair.
Thank you. Thank you.
Dr. Lebeya, can you go to file 1, which has your main statement? And it goes up to page 124. If you could just confirm that that is your signature on page 124.
I have the file, Commissioners.
Do you confirm that that is your signature on page 124?
The signature is mine, Commissioners.
Do you confirm the correctness and truthfulness of your statement?
The content are correct and truthful, and then we shall just indicate when we go on typing errors. Thank you, Commissioners.
Thank you. Commissioners, you will note that there are topics, many of them of a legal nature, where the General, if you'll forgive me if I do refer to you as General every now and then, my apologies, Doctor, where he deals with matters of legislation and regulations, regulatory requirements, and what we have agreed there is that because this affidavit will form part of the record which the commissioners will take into account.
Is it an affidavit, though?
A statement, Chair. I don't see a commissioner of oath.
Sorry about that. Please continue, and
Thank
sorry
you.
for the apologies for the interruption.
No problem, Chair. Chair, I was just indicating that there are matters which Dr. Lebeya deals with, which are of a legal nature, where he sets out the laws that govern SAP's operations. We have agreed that because this statement will form part of the record of the Commission, and that the Commissioners will take it into account when preparing the report, that he won't deal with that in his oral testimony, but that it will be noted, and I will have the task of noting that he has mentioned it, highlight the relevant sections only, place it on record, the sections that he addresses, and then we will leave that, which effectively cuts off about 20 to 30 pages of the first statement. We have reached that agreement. And then insofar as the General's background and his service history is concerned, he does traverse matters which predate his appointment as the head of DPCI. He has indicated that there are certain aspects that he does want to highlight. We have also identified certain paragraphs there, which he will read into the record, but the remainder will not be. So you'll just have to bear with us, Chair, as we go through it. Doctor, if we can then start with your statement. Page 1 has the table of contents, and 1 and 2, and we'll start with page 3, which is the introduction. And you basically just set out who you are, and that you are you were a member of SAPS, who held the rank of Lieutenant General. You're retired now, and you retired in May of 2025. May I ask you then to also then just at paragraph 1, if you can start with paragraph 1, read that into the record.
And perhaps start with your full names there.
Yes.
All. Thank you.
Seswancho Godfrey Lebeya. I am an adult male. I was a member of the South African Police Service, SAPS, holding the rank of Lieutenant General, appointed as National Head, and the former National Head of the Directorate for Priority Crime Investigation, DPCI, until I retired in May 2025. In this statement, I will also refer to the DPCI by its popular name, the Hawks, at other times. I'm currently a practicing law as an advocate of the High Court of South Africa, and I am a member of the Johannesburg Society of Advocates.
Lebeya, where you say you held the rank of Lieutenant General, in brackets you say appointed as National Head. Are you referring to the Hawks or to the SAPS as National Head?
National Head is in the Hawks.
Okay, thank you.
Okay, then paragraph 2 we can skip because you have placed that on record that you confirm the correctness of the statement. And then paragraph 3.
As I said, I was member of the South African Police Service holding the rank of Lieutenant General, appointed as National Head of the Directorate for Priority Crime Investigation, DPCI, in terms of non-renewable contract for a period of 7 years from the 1st of June 2018 until the 31st of May 2025. I retained the rank of Lieutenant General appointed as National Head in bracket R to avoid confusion with 7 members. In this statement, I will give credit where it is due and will indicate where there are some shortcomings, abnormalities, inaccuracies, or wrongdoing.
Thank you. At 4 and 5, you set out what the topics that your statement will address that you've been asked by the Commission to address. So we won't go through that because as we go through your statement, you will deal with those topics. Then if we can go to page 6, paragraph 6.
The gist of the issues that relate to me emanate from the opinions of witnesses A and B. Lieutenant General Mkhwanazi, who voiced the concerns on their behalf on the 6th of July 2025, have left it to them to present the evidence as he did not repeat same in his testimony. The allegations is that I was called by Katiso Molefe to send the Hawks to disrupt a legitimate police operation. Based on the opinion of witnesses A and B, Lieutenant General Khumalo draws an inference that the Hawks were at the scene to interfere with the operation.
May continue, 7.
It is my submission that the presence of multiple law enforcement agencies at the scene in Sandton on the 6th of December 2024 is indicative of a significant failure in the planning and the coordination of the operation. This situation reflects poorly on the effectiveness of the preparatory processes, as it suggests a lack of unified command and insufficient communication among the involved parties. Responsibility for such a lapse belongs to the overall leader of the operation. It is the duty of the operational leader to ensure that all the affected state agencies are adequately briefed and that their roles are clearly defined to avoid overlap, confusion, or unintended consequences. The inability to synchronize the actions of the various law enforcement units undermined the integrity of the operation and exposed serious shortcomings on leadership and operational oversight.
Can I just ask you there, General, you refer to all the affected state agencies, but you don't say who those agencies are.
The affected state agencies in this regard will be the Hawks as a part of a state agency, and the greater SAPS, such as the Organized Crime Unit, the station involved the SAPS at Santen. So those are the other state agencies that I'm referring to.
Okay, thank you. And then at paragraph 8.
The questions to be asked are, was this concentration of law enforcement agencies at the scene in Santen preventable? What should have been done to prevent such occurrence? Who should have ensured that that did not happen when it was happening and the leader was kept abreast with the developments? What did he do to defuse the situation? Was the custodian of the information of this operation not the Divisional Commission of Crime Intelligence, who is the custodian of information and intelligence in the SAPS? Is the Divisional Commission of Crime Intelligence not the service provider of all operational environments in the SAPS? Are all operational environments, including the DPCI, not his clients?
Can I just ask you, are these rhetorical questions or do you address them in your evidence? Do you answer them or are you asking us to answer these questions?
I'm asking witnesses A and B and whoever is suggesting that I have sent the members of the SAPS to the Hawks to go and interfere with the legitimate operation.
Thank you. Paragraph 9.
A confrontational atmosphere was established where various units had to respond effectively to the events purported to be taking place in Santen on the 6th of December 2024. That atmosphere might have led to unintended outcomes, including the possibility of friendly fire. Applying the conditio sine qua non theory, which refers to a condition without which nothing, or simply but for, one may reasonably conclude that if Lieutenant General Khumalo had informed me, as the national head of the DPCI then, about the operation, or if upon receiving a report about the presence of the members of the Hawks at the scene, he had checked with me, the situation would not have occurred. It is unfortunate that he cited the issue of trust.
10.
It is vital from the outset, it is vital to mention from the outset that the correct position which will be demonstrated is as follows. I do not know Mr. Katiso Molefe. I was not contacted by Mr. Katiso Molefe. I was contacted by Malcolm X. I directed 2 senior managers to verify the allegations of persons who were said to be claiming to be members of the DPCI and to have been sent by me. I have never instructed the members of the DPCI to interrupt a legitimate police operation.
Thank you. Then the next topic is some critical laws governing policing in South Africa. The first you mentioned is the South African Police Service Act, and as I've indicated, we're not going to read this entire section into the record. I do want you to, however, read 11 and 12, and also to place on record that the provisions in the SAPS Act that you highlight is 16, 17, and 28. But if you could just read 11 and 12, and then we'll continue from there.
The Directorate for Priority Crime Investigation, DPCI, is an entity that was established by the insertion of Chapter 6, capital letter A, in the South African Police Service Act 68 of 1995, which is a Police Service Act. That chapter came into existence following the amendment of the Police Service Act through the South African Police Service Amendment Act 57 of 2008. It came into operation on 29th of February 2009. The Directorate was formed as a division in the SAPS headed by the head, who was a Deputy National Commissioner. In the provinces, the Directorate was headed by provincial heads who were also Deputy Provincial Commissioners. Major General Arnold Ramat, who was the Deputy Provincial Commissioner in the Western Cape, was appointed as the head of the DPCI with the rank of Deputy National Commissioner. It is written on 6 July 2009. I just want to indicate that the effective date of appointment is the 1st of June 2009. On the 6th of July 2009 is the date on which he took the post in Pretoria.
Thank you. Paragraph 12.
The independence of the DPCI was questioned, and the law was changed in terms of the South African Police Service Amendment Act 10 of 2012. The consequences of this amendment is that Section 16, subsection 4, paragraph B, was incorporated into the Police Service Act that came into operation on the 14th of September 2012. Furthermore, the person to oversee the DPCI was to be the national head, who is accountable to the Minister of Police. The provincial heads were no longer the Deputy Provincial Commissioners, and their reporting line is to the national head. The national head determines the fixed establishment of the DPCI.
Thank you. Then you deal with a case, the Glenister case, and you highlight sections 16 and 17 in the following pages. If we can then go to page 13. So we're skipping 10, 11, 12. And if we go to 511, paragraph 15, 11, on page 13, where you deal with section 17E. This is an important section because it deals with security clearance and the cooperation between DPCI and crime intelligence regarding security clearance and vetting.
Section 17E, subsection 2, paragraph A, provide that no person may be appointed to the Directorate unless a security clearance has been issued to that person in terms of section 6 of the National Strategic Intelligence Act of 1994, Act number 39 of 1994, by the head of Crime Intelligence Division of the service, any intelligence structure referred to in that act as may from time to time be determined by the minister.
And then if you could read 15.14.
It is worth mentioning that in respect of the assistance from crime intelligence as provided for in section 17F, subsection 6, which provides for support of the directorate by crime intelligence, the directorate has asked crime intelligence to dedicate capacity to provide grabber services for the kidnapping cases and cash in transit CIT robberies related cases. This was not successful.
Sorry, Doctor, could you tell us what period this was? When was this? You don't say.
Since I took office in the DPCI, that is from 2018.
Thank you.
Crime Intelligence Division drew a document excluding the directorate from acquiring the grabber, a tool necessary to assist in cracking cases. Instead, the division will expect the directorate to produce the docket to be inspected by Major General Pidani Lushaba of Crime Intelligence to determine as to whether it is necessary to deploy a grabber. In one instance, an attempt to catch an imposter failed because of the DPCI could not produce a docket to crime intelligence. That would have dampened the operational independence of the DPCI. As for vetting, the DPCI has since 2018 been requesting the capacitation of vetting in crime intelligence as Section 17E of the Act requires 100% vetted officials in the Hawks, and the crime intelligence is only capable of vetting 15%. In some instances, it takes over 6 months to complete vetting on someone who is recommended for vetting before appointment in a senior management service post in the Hawks.
Thank you. And then 15.15.
Section 17F, subsection 4, which provides that the National Director of Public Prosecutions must ensure that a dedicated component of prosecutors is available to assist and cooperate with members of the Directorate in conducting its investigation, as well as secondment of persons with specialized skills as and when required.
Thank you. You then deal with the Public Service Act regulations regarding the Public Service Act for the remainder of that section. So if we could skip all of that and go to page 23, which is a background of my policing and service history. And if I could ask you in that regard, if we can start on paragraph 26 on page 24.
I have overseen detectives in Gauteng province from the year 2000 to 2004. I was the head of organized crime nationally from 2004 to 2010. After obtaining my Bachelor of Law degree, LLB, in 2005, I was admitted as an advocate of the High Court of South Africa in 2006. As the head of organized crime, I studied organized crime in the Southern African Development Community SADC region, focusing on motor vehicle crime, which I obtained Masters of Law degree, LMM, in 2007. I continued to study and obtained Doctor of Laws degree LLD in 2012 when I was a Deputy National Commissioner Crime Detection, the position that I held since the 1st of February 2011.
And which institutions did you obtain your qualifications?
The national diploma I obtained from Technikon South Africa, Technikon RSA at the time, the Bachelor of Laws up to doctorate, I got them from UNISA.
Thank you. And then paragraph 27.
I have been involved in investigating corruption cases since I was a constable at the time when corruption was still a common law crime of bribery. I have been on the forefront of fighting corruption in the country and I have never compromised my character. I have been issued with top secret security clearance certificates from the year 2000, and the last one is valid until the 30th of June 2029. I became the first casualty of addressing the criminality at Crime Intelligence Division for doing my work, and the division was never rehabilitated.
You say you became the first casualty of addressing the criminality at Crime Intelligence. When was this?
My investigation of activities in crime intelligence started in the year 2009. And I continued. I see that other witnesses have provided evidence, which is part of what I investigated. So I became a casualty when I was transferred out of the Hawks. My position shut down and appointed in the greater service. And in the greater service, I was dismissed from the police, probably because of the work that I was doing. I was rescued by the courts.
Okay,
Dr.
yes.
Lebeya, just so that we are clear, are you referring to the abuse of the secret funds when you say other witnesses have testified to the same issue?
I have noted that some of the witnesses, like Colonel Vulus, shall have investigated the activities in crime intelligence. So I touched on the Secret Service account. I also touched on the appointments of members in crime intelligence, the so-called 250 appointees.
All right, thank you.
Thank you.
And when you say you were excused, or I've forgotten the verb you used, you said you were excused by the courts. Did you mean you were reinstated?
Yes, I was reinstated by the courts.
All right, thank you, thank you.
Thank you. Then if we can go to page 31, paragraph 37. I think it starts on page 30.
Since joining the police, I was promoted and appointed in various ranks based on qualifications and experience. I was promoted and appointed to the rank of sergeant in 1988 and placed in the slow lane. Warrant officer 1990 and kept in the slow lane. Lieutenant in 1991 and kept in the slow lane. Captain 1993 and kept in the slow lane. Moved to the middle lane. Superintendent 1996, kept in the middle lane. Senior Superintendent 1997, kept in the middle lane. Director in 2000, moved to the first lane. Assistant Commissioner in 2000. Returned to the slow lane. Divisional Commissioner 2010. Lieutenant General appointed as Divisional Commissioner in 2010, moved to the middle lane. Lieutenant General appointed as Deputy National Commissioner 2011, moved to the slow lane and cul-de-sac. And Lieutenant General appointed as National Head, DPCI 2018.
You're going to have to explain all those lanes to us, please.
This is the imaginary lanes that are not spoken to. but you will see as the promotion progresses that yours is slow and your colleagues are going faster. As an example, when we were to be promoted to become sergeants in 1988, when you pass your examination in the first semester, like I passed my examination in June, I expect to be promoted from the 1st of July of that year. And those who pass their examination in December get promoted on the 1st of January. I pass my examination in July, I wait, I'm not being promoted. Those who come to write their examination in December get promoted before me, and then I get promoted after them. You are in the slow lane. When I pass my examination to become a warrant officer, I'm told, no, you haven't finished 2 years as a sergeant. You must first finish 2 years. So that period that you were put in the slow lane on is now counted that you haven't finished. But I have finished the qualification that are required. So I had to come and challenge this at later years, I think 1993, and as a grievance. They come and reverse all of those starting from sergeant, then you are put back in the correct lane. So those are the things that I'm talking about. Thank you, Commissioners.
What is the middle lane and the cul-de-sac?
The middle lane is when you are promoted normally. The promotions in the past, it was that if you finish 2 years as a sergeant, you can be promoted to become a warrant officer. So normally, when you finish 2 years and then there is nothing wrong, you have completed your qualification that are required, you are promoted. You finish 1 year as a warrant officer, you can be promoted to become a lieutenant and the like. So those are normal. The only reason that you will be excluded is if there is something wrong with maybe departmental hearing against you and the like, then you will be put in a slow lane. You will not be promoted like others. So that is the middle lane. The cul-de-sac that I'm talking about is that you have reached the end. So there is no move forward.
So yours was the appointment as the national head of DPCI?
At the time of cul-de-sac was when I became the Deputy National Commissioner. And then we are supposed to be, if the National Development Plan was being implemented, we could be given an opportunity to compete fairly. But because that process is not implemented, you reach cul-de-sac, and that is where they even think of moving you from where you are as the Deputy National Commissioner to something down, which is demotion.
Thank you.
Are you saying that there is no competitive for Deputy National Commissioners? There's no competitive process for them to be considered for National Commissioner? Is that what you're speaking to when you say cul-de-sac and in the way you describe it?
The Commissioner is correct to say that there is no competitive process. The National Development Plan of 2030 is supposed to have corrected that anomaly. And what we are even seeing today, the appointment of individual without competing with others, is because of the absence of that. And I think that we have made some recommendation as to how that particular situation should be corrected. So currently there is no proper competitive process. And I think that with the last appointment of the National Commissioner, they tried to do something where they shortlisted individual, but you did not open for people to apply. You have just identified individual and say that you are shortlisted. You don't know what informed that. So there is supposed to be a process where people can be able to compete properly. Thanks, Commissioners.
Dr. Lebeya, can I get a yes answer, not elaboration? I just need to be clear here. Are you saying once you are DNC, Deputy National Commissioner, when you are then appointed National Head, DPCI, that's not a sideways movement, that's a demotion? Or is a DNC at the same level as head of the Hawks? I just wanted to be clear.
DNC and national head are on the same level. That is not the movement that I have taken, commissioners.
All right. So you're not suggesting that it was a demotion to move from DNC to head of the Hawks? Because they're on the same level, it was a sideways movement.
I'm not sure because the commissioner is asking a yes and no, and it needed to be clarified, or how did it happen? Because I exited the organization. I did not move from DNC to National
okay,
Head.
I get you. So you exited and then had to come back?
Yes,
And
this
then
one
you
is
were given the
totally separate
Yeah.
appointment,
Yeah.
contract appointment. So I was on retirement.
I'm with you.
I remained retired, and then I had to be appointed on a contract basis, which is separate.
No, you've clarified. Unless Chair wants you to deal with the other movement, I'm sorted. Thanks.
Can I then just ask, Doctor, so when you are the Lieutenant General appointed as Deputy National Commissioner in 2011, and you say you moved to the slow lane, what was your expectation to be appointed as National Commissioner or?
So on that level, as the Deputy National Commissioner, you are Deputy National Commissioner, and then if an opportunity arises to move to the next level, is where you are supposed to compete with others.
Okay, and you say you deal with that later as to what should have happened in that period?
Yeah, I will touch on that.
Yes, okay. Then at paragraph 38, I don't want you to deal with the entire paragraph. You mention National Instruction 2 of 2001, which deals with issues relating to informers. If you can just tell us about that National Instruction, I don't want to really deal with 38 because it does become an important aspect of your evidence later.
Yes, without reading this paragraph, commissioners, it's just an indication that in performing duties as a police official, from time to time, you get assistance from people who volunteer information. There has been different labels that are put on people who are volunteering the information. And then a National Instruction 2 of 2001 came into place to assist with the registration of informers and the remuneration thereof. Even before this instruction came in place, there has always been a practice of utilizing informants. I have been utilizing that effectively from the time that I was still working at Hillbrow. People from different areas phoning, providing information about the existence of firearms. You get that information, you task people, not telling them where you are getting information. They must just go and execute. That is how you deal with information coming from people who are prepared to tell you as a police so that you can solve crime. So that is in essence the importance of that national instruction.
Thank you. And then if I could ask you to go to paragraph 43, but if you wish to deal with 41, I would ask you, then you may do so, but I would want you to do 43.
When I left the DPCI, it was on a sound operational footing as on 2010 to and 2011 financial year, which is the time that I left the DPCI. Its performance was unparalleled performance of 14,793 arrests and 7,000 37 convictions.
And then on page 37, paragraph 48.
On the 17th of August 2009, I was expressly assigned by the Deputy National Commissioner Dramat to investigate the allegations of murder of Oparamukibe affecting crime intelligence based on the information note compiled by Assistant Commissioner Bushi Engelbrecht, one of the best investigators that the country produced. I complied. On the 24th of October 2010, the Saturday Star newspaper published a detailed article about irregularities at crime intelligence. The story included mismanagement of crime intelligence division, appointment of criminals, and nepotism by appointing official in covert component. On 26 October 2010, while I was the divisional commissioner at the Hawks, General Keller assigned me to investigate these irregular appointments at crime intelligence. I established that the family members of personnel in crime intelligence were irregularly appointed in covert environment. My post of divisional commissioner was abolished on the 31st of January 2011.
Are you saying it was as a result of this investigation, or was it just coincidence?
It was not said what is the reason for closing the position that I'm holding in the Hawks, but when it got phased out, I have to speculate on what is the reason. It's the investigation that I'm conducting. So it was not stated.
Thank you. Paragraph 49.
I was appointed as Deputy National Commissioner of Crime Detection on 1st February 2011, and I continued with departmental cases of crime intelligence. On the 3rd of March 2011, Crime Intelligence Division was restructured, and the Divisional Commissioner was to account directly to the National Commissioner on covert component, while he accounts to the DNC crime detection on other components. Copy of appointment as Deputy National Commissioner is attached as Annexure SGL 13.
Thank you. Then at paragraph 52.
Over and above these two portfolios, on 29 July 2011...
Sorry, General, 52.
52.
Yes.
On 24 October 2011, when the former President Jacob Zuma suspended General Keller and announced the appointment of Major General Sibusiso Ntahla Mkhwanazi as the acting National Commissioner until further notice, as the person that he trusted, I was one of the 30 lieutenant generals that formed what is called top management of the SAPS. After a public outcry, Major General Mkhwanazi, who had a few months in the rank of Major General, was on 26 October 2011 promoted to the rank of Lieutenant General in terms of what was recorded as Section 207, subsection 1 of the Constitution of the Republic of South Africa, 1996. The letter of appointment dated 27 of October 2011 is attached as Annexure SGL 15. It is on this day that Brigadier Sharon Gayler sent an email to Lieutenant Generals Pahlani, Nchwe and me, directing as follows: "Good day, Lieutenant General. By direction of the Acting National Commissioner, Major General Mkhwanazi, you are kindly requested to attend the funerals as guardians of the Eastern Cape. Major General Mkhwanazi will not attend. Thank you very much. Respectfully, Brigadier Gaylor, Executive Assistant to the National Commissioner, General B.H. Taylor, South African Police Service. Copy of this email is attached as annexure SGL 16.
I just wanted to ask you, why are you referring to this email? I don't understand its relevance.
I wanted to demonstrate the interference of politics in policing, that it comes way back from 2009 in terms of my view. Others may push it back. I have had others putting it since the Bologwani period. But from the work that I have been doing, I have seen it from 2009 that there is a serious interference by politics in policing matters.
Sorry, you'll forgive me, but how does you getting an instruction to attend a funeral, what does that have to do with interference?
Under normal circumstances, a junior, a subordinate will not give an instruction to a senior officer. It is only when there is interference that there is that confusion.
And who's the junior, the brigadier?
No, the instruction comes from a major general instructing lieutenant generals.
But isn't he at that point, isn't he in an acting role?
Yeah, that is the incorrect processes that is being done. You don't appoint a junior to instruct seniors.
Okay, that's the point you want to make regarding that. Then if we can go to 55 on page 41.
Still on 27 October 2011, 5 officials from crime intelligence hatched a conspiracy theory against General Tele, Lieutenant General Mzwandile Petros, Lieutenant General Arnold Dramat, and me. On 3 November 2011, the Divisional Commissioner of Crime Intelligence wrote a letter to the President, the Minister of Police, and Lieutenant General Mkhwanazi to lodge a complaint of conspiracy.
Sorry, can I just ask, who was the Divisional Commissioner of Crime Intelligence then?
The Divisional Commissioner of Crime Intelligence was Lieutenant General Mdluli.
Thank you.
On 12th of May 2012, a task team was set by the Minister to consider the complaint. While this cloud was hanging over our heads, General Pierre was appointed as the National Commissioner on 12 June 2012. On the 5th of July 2012, Minister announced that the allegations of conspiracy were unfounded. When I asked a copy of report in the letter dated 23 of November 2012, the Minister refused via a letter dated 6 December of 2012 on the ground that it is for cabinet.
Thank you. 56.
The acting National Commissioner who directed that grabbers be moved away from the DPCI to crime intelligence amended the list of senior managers who could recommend the interception and monitoring. The amended list required the acting National Commissioner and the acting Divisional Commissioner to be the only ones who could recommend the application of interception and monitoring to the designated judge as appointed in terms of regulation of interception of communication related information Act 70 of 2002. That was a serious anomaly and it created more risks than solutions. I had to come and finalize the assets record during my era as national head, as the equipment were still in the name of the DPCI.
And when you say in that paragraph, the acting national commissioner who directed that grabbers be moved away from the DPCI to crime intelligence, who was that acting national commissioner?
The acting national commissioner at the time was Lieutenant General Mukwanazi.
Thank you. Paragraph 57.
While the investigation of crime intelligence was continuing, information of threat was brought to our attention. Based on that information, a threat assessment was commissioned by then acting Divisional Commissioner of Crime Intelligence, Lieutenant General Masemula, as per letter dated 14 of February 2012. Based on this, I received one-day protection. Copy of the letter is attached here to as annexure SGL 19.
And then paragraph 58.
On 24 February 2012, during the Deputy National Commissioner and the National Commissioner morning sessions, Lieutenant General Mukwanazi informed us that he had met the state president, who told him as follows: I keep on hearing this name, Lebeya, Lebeya. Lebeya, Lebeya. Who is this Lebeya? He told us that he explained to the president that Lebeya was a general who was just trying to do his job. Lieutenant General Mukwanazi submitted his statement to the State Capture Commission in this regard. He directed me to write a letter to the state president to explain why I investigated the then Divisional Commissioner of Crime Intelligence, Lieutenant General Nakim Richard Mudluli. On the 3rd of February 2012, I submitted the letter to the acting national commissioner, which was addressed to the state president, the Minister of Police, and the acting national commissioner as communication of that nature had to follow those channels. Lieutenant General Mukwanazi advised that I should address the letter only to him, and he would in turn communicate with the president. I then changed the addressees to him alone, which reduced the volume of the letter to 10 pages. The letter had annexures that made 86 pages and was classified. The report answered the allegations that I was colluding with Dr. Matthews Posa, Lieutenant General Lala, Lieutenant General Praise, and Major General Freyer. I concluded the letter by stating that, I quote, I am hoping that this information will assist in balancing the level of the scale of trust painted by those who may have presented a picture about me without me, I close quote.
Thank you. Paragraph 59.
On 28 of March 2012, Lieutenant General Mukwanazi informed the Deputy National Commissioners that the Minister of Police have directed him to appoint another Major General as Divisional Commissioner without advertising the post. He complied with the directive and circulated the appointment on 30 March 2012, with the appointment becoming effective on the 1st of April 2012.
Can you just clarify who was the Minister of Police?
The Minister of Police was Minister Mtetwa.
And who was the Major General to be appointed as Divisional Commissioner?
The Major General was B.S. Mngubane.
Thank you.
The appointee was to report directly to the acting national commissioner, which is not structurally correct, as the post fell under the deputy national commissioner for physical resource management. Indeed, the predecessor to the appointee reported to the latter. A letter of appointment is attached as annexure SGL 20. This shows that political interference has been taking place since 2009. On the same day, Lieutenant General Mukwanazi restructured the division crime intelligence away from crime detection to report directly to the National Commissioner, leaving the detective service and forensic services as the only division resorting under Deputy National Commissioner Crime Detection. Letter of restructuring is attached here to as per Annex SGL 21. He further appointed Lieutenant General Fanima Semula, who he had earlier appointed as the acting Divisional Commissioner of Crime Intelligence, as Deputy National Commissioner Policing with effect from the 1st of April 2012. He provided me with a letter of appreciation for acting in such a position from the 10th of April 2011 to the 31st of March 2012, which is attached as per Annex SGL 22. He also provided me with a letter indicating that I should sign an agreement to be responsible for the two divisions, Detective Service and Forensic Services. A copy of the letter is attached here to Annex SGL 23.
And then paragraph 62.
After the appointment of General Pierre, Lieutenant General Mukwanazi did not have a post, as he never had. He was reflected on an island in the structure, and later a post was created for him called Facility Management and Operations. It is from that moment that the rank was regularized.
By the rank, you mean Lieutenant General?
Yes, the rank of Lieutenant General, because in terms of the regulations, at the time when it was announced, we didn't have a rank of Lieutenant General in that fashion in terms of the regulation. The rank of Lieutenant General existed in 1990, 1992 and 1993 amendments of the regulations. In 1995, it fell off, so we never had Lieutenant General that is not married, that is not attached to specific post. That is, you have to be having Lieutenant General. That's why there is always something in bracket. It can't be Lieutenant General without anything in bracket. That is how the regulations are written.
Okay, paragraph 63.
During 2012, I was tasked by General Pierre in the presence of the Minister of Police to deal with the cases of political killings in Mpumalanga.
Sorry, Doctor, when you say Minister of Police, if you could just say who it was at the time so that we can keep track.
During 2012, I was tasked by General Pierre in the presence of the Minister of Police, Honorable Mtetwa, to deal with the cases of political killings in Mpumalanga. When I asked for copies of these cases from the provincial head of the DPCI in Mpumalanga, he advised me that the divisional commissioner had already asked copies. When I checked with the divisional commissioner of detective service, he told me that he has been tasked by the national commissioner. It was a divisional commissioner who reports to me, who was tasked by the national commissioner, signaling that she was, in my view, politically instructed not to task me on matters resulting under my responsibility.
And who was the Divisional Commissioner of Detective Service that you're referring to there?
The divisional commissioner was Lieutenant General Munu.
Thank you. Sorry.
The restructuring which has been used by every national commissioner, including the acting national commissioners, has been used to either constructively enhance the organization, destructively weaken the organization, negatively weaponize it against adversaries, and nepotistically created posts to accommodate loyalists. On 12 August 2012, General Pierre indicated that she wants to restructure the police and reduce the number of deputy national commissioners. The first restructuring came on the 30th of August 2013. I was offered a post of head SAPS Research Institute. I was to move from a post of deputy national commissioner to a post of head SAPS Research Institute, which meant that I would have been demoted as defined in section 186, subsection 2, paragraph A of the Labor Relations Act 66 of 1995. Demotion must be preceded by a board of inquiry as provided for in section 34 of the South African Police Service Act of 1995, read in conjunction with Regulation 64 of the South African Police Service Regulations of 1964 and Standing Order General 121 1D. That is the treatment that I endured in the police for fighting corruption.
Paragraph 66.
I was dismissed by General Pierre on the 31st of May 2014 without following a legal process, indicating that I refused to accept the post. However, she placed me on pensions roll because the system did not recognize the novel dismissal, which she called self-redundancy. After full 2 years of this unlawful treatment, the court reinstated me on the 16th of May 2016 and discharged me on a no-fault discharge on the 31st of May 2016, which is a form of retirement. During the last month's discussion with the police, I've offered to take the post of Deputy National Commissioner, Crime Detection, which was now re-established through restructuring. I was told that the acting National Commissioner said that he had already placed senior managers in posts. When I said, but there is no one appointed in the post, they just said, no, it would appear that it is from above. The SAPS expressly apologized for all the treatment I received, which I accepted. I attached copies of certificates of service dated 9 December 2014, 1st July 2016, and 2 August 2016, as well as a letter of apology as per Annexures GL 24.
Then at paragraph 67, you refer to several attempts that were made to get rid of you by colleagues and individuals of highly questionable character. But could I ask you to deal with subparagraph 67.3, 4, and 5?
Maybe before you do that, Dr. Lebeya, in paragraph 66, who is the acting National Commissioner at this point?
The acting National Commissioner was Lieutenant General Patlane. Paragraph 67.3. Major General retired Advocate Ngitsini Prince Mugotedi reported me as protected disclosure to the authorities, including the presidency, the ministry, and parliament, to the effect that I'm occupying the post unlawfully, contrary to the provisions of Chapter 6, capital letter A of the South African Police Service Act, as corrected by the Constitutional Court.
And which position is this that you're referring to, that I was occupying the post unlawfully?
This is the position of national head of the DPCI.
And when did he report this?
I think that it is just before his disciplinary processes was finalized. I think it's 2021, around 2021. I do not have the specific date.
Okay. And 67.4?
Another former police official, advocate, now no longer advocate, Malesela Daniel Defu, reported me to the authorities, including the presidency, ministry, and the parliament, to the effect that I am occupying the post unlawfully, contrary to the provisions of Chapter 6, capital letter A of the South African Police Service Act, as corrected by the Constitution.
And 67.5?
Paul Robert O'Sullivan, a private investigator, made similar allegations and lodged a case at court contrary to the provisions of Chapter 6A of the South African Police Service Act as corrected by the Constitutional Court. He only withdrew the case when our response shows that provisions of the law that he relies on was deleted by the Constitutional Court. Our relationship has always been cordial until I refused to provide him with the status of a case that the directorate were dealing with.
And when was this? What year are we talking about?
I think that it is 2023, 2024.
And do you recall what case he was asking about, the status of the case?
Yes, I do recall the case he was talking about.
Is it a case that you can mention here or no?
It is, without detailing it, it is commonly known as the Pala matter.
Okay, he was asking you for a status update on the Pala matter.
Yes, when he phoned me, he said that he's sitting here with his friend who's a doctor, and then I just need progress of this status of the case.
And did he say in what capacity he was asking for the status?
He did not say, but I just felt somebody else is asking me to provide him with the status of the matter that is handled by the Hawks. And he tells me that he's sitting with his friend doctor. They have got nothing to do with that. I can't report to any other person about progress of matters in the DPCI. So I did not ask him your status because I know he's not a lawyer, and I couldn't understand why he will ask me to provide him with the status of the case.
Did he mention the friend who's a doctor that he was sitting with by name?
He did mention the friend that he was sitting with, commissioners.
And he said, the name is what?
He said that he's sitting with Dr. Benjani Chauke, his friend.
Thank you.
You say in the same paragraph, Dr. Lebeya, that your relationship has always been cordial until you refuse to provide. What was the nature of your relationship up to that point?
Mr. O'Sullivan, the first time I knew about him was, I think, 2001, when he was the complainant on the cases against National Commissioner Lebeya. So I was in charge of the detective service in Gauteng. So this matter resorted under the detective service in Gauteng. So I had to appoint people to conduct the investigation. So I even had to visit his office so that he go and show me where he says that he made a U-turn when the people wearing balaclavas were shooting at him. So it is those kind of cases that I knew him. And later on, I think that it is somebody else who has been providing information. And then he also came to my office at some stage. So it is somebody else who report matters. He does report matters. In some of the matters, he's the complainant, where we have even effected arrest when we didn't have a complainant. So he is that type of person, and then information from time to time, he will email to different people. So that is how I know him.
Thank you. Chair, may we take the tier chairman now?
Let's adjourn and resume at 11:30.